You're here today to better understand automobile accident lawsuits, and Jonathan DeLoatche of Williams DeLoatche is joining us today. Thank you so much for joining us.
Thank you very much for having me.
So we're talking about automobile accident lawsuits, and one of the things you need to know is the statute of limitations and really jumping on top of it early.
Exactly. The statute of limitations in the state of Virginia is 2 years. So that means you have 2 years from the date of the accident to file a lawsuit. But that certainly doesn't mean that you should wait 2 years. As soon as you get into an accident, it's always important to gather as much evidence as you possibly can, witness statements, pictures, anything that's going to help you prevail in court. It's very important to do that timely and ahead of time. So we don't recommend waiting till the last minute.
So what about liability? You know, I mean, I think sometimes we just wonder, who's at fault in a car accident?
Well, again, collecting information at the very outset of the case is very important. Photographs of the accident scene, getting a police report, getting any statements from witnesses who observed and were eyewitnesses to the accident. So a lot of times cases depend on the veracity of the people involved to tell the truth, who actually had the light. And many times we see clients who come in and swear that they had the green light while the other party says that they have the green light. And in that case, the plaintiff who brings the suit has the burden of proof of showing that they actually had the green light. And if a judge or a jury does not know who to believe between the plaintiff and defendant, the plaintiff loses. They have to carry that burden of proof in order to collect in Virginia.
And in Virginia, there's something called contributory negligence law. That makes us unique.
Correct. We are only one of 4 states in the entire country, along with the District of Columbia, that have contributory negligence law. And what that basically means is that if you're in any way, shape, or fault for the accident itself, you cannot collect in the state of Virginia. By comparison, other states have what's called comparative negligence. So if you went to a jury trial and a jury deemed the plaintiff 10% at fault and awarded $10,000, they would collect $9,000 in that circumstance. In Virginia, if you're deemed 10% at fault or 1% at fault, you cannot collect a dime.
So if you're at fault at all, you don't get anything.
You don't get anything if you're deemed at fault at all.
Okay. So how can people find out more information?
Well, they can go to our website at wd-law.com, or they can contact us at 757-547-5555.
And really, I think you recommend call you.
Absolutely.
It's a free consultation.
Absolutely. Whether you retain an attorney or not, you should always contact an attorney to determine your rights. And we're more than happy to give those rights just over the phone for anybody who contacts us.
Okay, great. Thank you so much for joining us today.
Thank you very much.